Good evening, class. In this lecture, particularly, we have been doing, or we've started with the Indian Constitution, and this is our fourth class, or maybe the third class rather, because the first one was the orientation session. So, if I speak of this particular class, or say, this class as what is the topic that we will be discussing in here. So it will be dealing with two things. For this class, we will be taking care of two things in this class. Good evening, Deepak. And there are two particular topics that we would like to, discuss here. So first is the features of the Indian Constitution, and second one is, we all know that we have borrowed the Indian Constitution from various parts, or, from various different places, from different countries in the world. We have borrowed our Constitution. So in the previous three classes, or last two sessions rather, because the first one was the orientation session only. So in the last two classes, we have been, we've done two things. We have completed, to understand, or we've tried to understand what do we mean by the Indian Constitution. And yes. Okay, we've tried to understand what does the Constitution means, how it is supreme, and in the other lecture, we tried to understand how is, the Constitution that we have in the present format, how that has been received, or what is the historical background. So we were able to cover three things particularly. If I speak of the previous sessions, we were able to understand, what is we were able to understand what is the Indian Constitution all about, how it is supreme. So we've done three things, particularly the supremacy. We've done supremacy of Constitution. Then we've done its historical background. After that, we've understood why do we need it, and the meaning. Along with that, we also we've given two classes rather, to understand the historical background, understanding the milestones which have made the Constitution to come into existence, all the history, the story behind how did it come into existence rather, until 26th of January 1950. So this class particularly will be dealing about what are the sources of the Indian Constitution and what are its features. So when I speak of the sources, we can have a number of countries, about the sources of the Indian Constitution, as as an area of focus. So we are here concerned with two things: the sources from where we have borrowed it, and secondly, the features. So we will start with the features first. So primarily, when we speak of, what can be the features, so there are, rather, I would say, 9 to 10 or 11 features which would, we generally can say that the Constitution has it. So सबसे पहले तो we can start with that it is a written Constitution. Fine, it is written, it is the longest, it is the bulkiest. Okay, bulkiest and longest, as in when it was made, it had 395 articles, and it has now, it has 12 schedules and parts in it. So it is the bulkiest and the longest written Constitution ever, and the Indian Constitution was rather handwritten. ये feature अगर हम इसको गिनते हैं सबसे पहले तो, then we can say that it speaks of fundamental rights. It speaks of fundamental rights. Then it speaks of the federal structure. We will be doing all these features, one by one in detail today. We will be doing the federal structure. So we have a quasi federal structure, which is key. The center is strong with, the units around. So a quasi federal structure with a strong center. Then we have parliamentary form of government. Parliamentary form of government. Okay. So quasi-federal structure we've taken from Canada. The parliamentary form of system or the parliamentary system of government we've taken from United Kingdom. Then we also have the idea of rule of law imbibed, which we have, transported from the United Kingdom. Our judiciary is independent, or rather independent judiciary that we have, the idea of independent judiciary. Then judicial review is also, one basic feature or prime feature of the Indian Constitution, and we've taken this from the US. Along with these, the other things that we might put into place can be, we have this concept of single citizenship. Okay, we've taken this from United Kingdom. Then it is, of course, this is also a feature that it is drawn from various sources, from different sources, which is, it can be the Government of India Act of 1935. Basically, the structure is, imported from the Government of India Act. Then countries like US, UK, France, Germany, then South Africa, USSR, okay, so on and so forth, Japan, Ireland. So many of these, from many of them, we've taken a lot of different things. Then we also have, fundamental duties. So fundamental duties, it was not there when we enforced our constitution. It was particularly not there when it was, enforced on 26th of January 1950, but it was added through the 42nd Amendment, okay, in 1976. But still, nevertheless, it is a function, it is a feature. Then we have the concept of universal adult franchise. Universal adult franchise means that we provide, our citizens who are over 18 years of age to, vote, to choose a representative for themselves. और ये जो चीज है, we have it from the very beginning only. तो जैसे ही constitution बना था, हमने voting rights जो थे, to choose a government of your own wish, we had provided it. However, when it came into existence, the age was 21 years जब कॉन्स्टिट्यूशन बना. बाद में ये वोटिंग राइट, जो ये आपका लीगल वोटिंग राइट है, इट वाज मेड 18 इयर्स. अब एज 18 इयर्स है, एंड इट वाज मेड इन 1988 थ्रू 61st अमेंडमेंट. ओके, through 61st amendment it was made 18 years for everybody to vote or to choose a representative for themselves. Then along with these things, we can also add up another feature here, that is secularism. Okay, secularism is a part of Indian Constitution from day one. मतलब जैसे ही enforce हुआ था, it is, a part. It is a part of the Indian Constitution from day one. However, ये जो word है, secular term जो है, this term was added to the preamble through the 42nd Amendment. Okay, so we had the idea of, practice a religion of your choice. Article 25 was there from day one. from the beginning. But the word secularism in itself, this concept, I would not say had come up after 42nd Amendment, but the word, to make it more prominent or to make it more, revealing rather, it was added by the 42nd Amendment, 1976. Okay. Now, along with that, our constitution का दूसरा या और कोई scope क्या, feature क्या हो सकता है? We can say that it is, it is rigid but flexible. Okay. For few things you require 2/3 of majority, present and voting in the parliament, and for others a simple majority may be okay. So the amendment process is what it is speaking here. The amendment process present in Article 368 is rigid and a flexible method. It is a blend of both the methods. Then we have directive principles of state policy. This is also a fundamental feature of the Indian Constitution. We have directive principles of state policy, which are goals, which need to be achieved by the Indian government in whatever laws that they are laying for the country. Now, when we have to speak of, what are actually, what can be the list? What is the list? If I have to give you a list, I will provide you with, the various features. Okay. The various features of the Indian Constitution, which are borrowed from different countries. So when we have to speak of these features which are borrowed from different countries, I will try to create or, write on the screen all those countries with those features which are, borrowed from there in India, and the names. So you will be able to, at the end of the class, make, notes or a chart for yourself, which will make it easier for you to understand in a better manner. So we'll start with USA. So USA से हमने लिया है fundamental rights. Fundamental rights. Then we've taken the preamble. We've taken the concept of written constitution. Okay. Then we've taken the idea of judicial review. I will be explaining all these things which are important from the perspective of their meanings after I, I just provide with the entire table. Okay, don't worry. So then we've taken the concept of removal or impeachment of judges of the Supreme Court and the High Court. So removal of judges of High Court and the Supreme Court, both. Then we've also taken the concept of post of vice president. Okay, so this particular idea was taken from USA. Equal protection of laws. This procedure, equal protection of laws, and the idea of due process of law. ड्यू प्रोसेस ऑफ लॉ ये स्पेसिफिकली मेंशन्ड नहीं है इंडियन कॉन्स्टिट्यूशन में, बट we still follow while we are trying to interpret the concept of equality in India, or we are trying to interpret the concept of equal protection of laws, or equality before law, or rule of law, or these things. When we are trying to understand, we do apply this principle as well. Now coming to the other country, I would like to write here. Wait. I would like to now start with the British Constitution. Okay. The British Constitution we know is an unwritten constitution. ठीक है, तो unwritten constitution वैसे सिर्फ British का ही नहीं है. Unwritten constitutions, you can also call the Constitution of China to be majorly unwritten, the Constitution of Israel to be unwritten, then Saudi Arabia to be unwritten. So it is not that it's only the British Constitution which is unwritten, even New Zealand's Constitution is unwritten. So Britain Constitution से हमने what all things have we borrowed, okay, for our constitution is we borrowed the parliamentary form of government. parliamentary form of government. We've borrowed the concept of rule of law. Then we borrowed the idea of equality before law. Before law. अब ये याद रखना, equality before law ब्रिटिश से लिया है, equal protection of law अमेरिका से लिया है. ठीक है. Then we've taken the legislative procedure. The legislative procedure is taken. Concept of parliamentary privileges. Privileges is taken. We've taken the cabinet system. Okay, we've taken the idea of bicameralism. Bicameralism matlab two houses. The two houses, Lok Sabha, Rajya Sabha. Okay, in Britain they have the House of Lords and Commons. We have Lok Sabha and Rajya Sabha. So House of Lords is for Rajya Sabha and House of Commons is for Lok Sabha, which is the House of People also. Then the concept of writs mentioned in Article 32 and 7 of the Constitution, 226, 227 of the Constitution, we have taken from from the British Constitution. Then we've taken the idea of single citizenship. This is also a fundamental feature. ये हमने last slide पे discuss किया था. Single citizenship. Okay, so part 2 of the Indian Constitution rather. Part 2 जो है वो citizenship के बारे में बात करता है और Article 9 particularly single citizenship के बारे में बात करते हैं. उसके अलावा we've taken the office of the Controller and Auditor General of India. The office of CAG is also been borrowed from the Constitution of the Britishers or the United Kingdom. Now, if I move forward, we can say there is another country which is, given its help or given some kind of provisions from which we've borrowed things for ourselves. That is Ireland. So Ireland say we have taken particularly 3 चीजें ही. We've taken DPSPs, जो कि आपके part 4 में है. These are guiding principles for any government. We've taken the nominated members. Nominated members to Rajya Sabha. This is been derived from Ireland. And the third one is the manner of election of the president. Manner of presidential election. Okay, so which is particularly given in Article 55 में जो दिया हुआ है. So manner of election of president is taken from Ireland. Moving to Canada, I'll be clearing the canvas now. So Canada has provided us with this concept of rather I would say Canada has provided us with the idea of a quasi-federal structure or federation with a strong center, federal structure with strong center, or you can say the idea of quasi-federal constitution. Canada has given us this. इसके अलावा we've taken our residuary powers. The residuary powers which lie, in the center are taken from Canada. Residuary powers means that in case if you do not know that where, who has power to make laws on these particular issues, whether the center, whether the states. So the miscellaneous provisions which are left after deciding the, the concept of states and union. So the residuary powers, they lie in center, and that is we've taken it from the Canadian Constitution. Then appointment of governors. Appointment of governors by by the center. This idea is also taken by the Canadian Constitution. And the last one, the advisory jurisdiction of Supreme Court, pertaining in Article 143 particularly. तो Canadian Constitution ने हमें 4 चीजें दी है, फेडरल स्ट्रक्चर विद स्ट्रॉन्ग सेंटर और क्वाजी फेडरल status of the Indian Constitution or the federal structure in India, residuary powers in center that which are available to the Union, and appointment of governors by the center, and the advisory jurisdiction of the Supreme Court as mentioned under Article 143. Coming next to is Australian Constitution. So Australia से हमने concurrent list ली. We've taken particularly 3 things if we speak of. So we've taken, I think I need to so from the I'll create a new board only. So from the Australian Constitution, we've actually borrowed the idea of concurrent list. Okay, so concurrent list in India is it has those subject matters on which both the center and the state can make laws. For example, the subjects of marriage, the subjects of personal laws. So both the centers can also, the union government can also make laws in it. The union parliament can also make laws in it. The state legislatures can also make laws in it. Okay, criminal law, for example. So even in IPC, maybe you might have seen that after any provision, any punishment or any kind of definition, there are different states names provided, okay, which may be a law or an offense in those states. So examples like personal laws, examples like criminal laws or criminal procedures, okay, on them the union can also make laws and the states can also make laws. So those subjects on which both the union and states can make laws are known as the concurrent subjects, and we have taken this idea from Australia. We've taken this idea from Australia, and the things that we've taken from Australia is the concurrent list. Okay. By the way, the concurrent list is in the 7th schedule of the Constitution, and it has 47 subjects in it. Then we've taken the idea of the concept of freedom to trade or freedom of trade. Okay, the freedom of trade and commerce and intercourse. Okay, the freedom to trade, commerce, and intercourse has been taken by the Indian Constitution from Australia. Thirdly, the joint sitting of both houses of the Parliament. The joint sitting of both houses of Parliament has been also taken from the Constitution of Australia. Okay, now coming to the Constitution of Germany. Okay, one thing that we've taken from Germany is the concept or the idea that during the times of emergency, Germany से एक ही चीज है that during the time of emergency, fundamental rights can be suspended. So suspension of fundamental rights during emergency has been taken from Germany. Okay. Fundamental rights to be suspended has been taken from Germany. From Soviet Union, if I have to tell, we've taken 3 things particularly, rather 4 laga lo. We've taken fundamental duties, फंडामेंटल ड्यूटीज, अब फंडामेंटल ड्यूटीज जो है वो 46th अमेंडमेंट से ऐड करी गई थी 1976 में. इट वाज नॉट देयर व्हेन द कॉन्स्टिट्यूशन गॉट एनफोर्स्ड. देन वी हैव टेकन द आइडियाज ऑफ justice in the preamble, and we have also taken the idea of or the concept of 5-year plans, 5-year plans, or the idea of planning commission. Okay, now it is very important. अब सोवियत यूनियन से एक चीज हम लोगों को रिलेट करनी है कि सोवियत यूनियन से वी हैव टेकन द कॉन्सेप्ट्स ऑफ justice. Justice from Soviet Union, the concept of justice, matlab 3 kinds of justice: economic, social and political, from Soviet Union. Then we will come to France. Okay, from France we've taken the other 3 things which are mentioned in the preamble. So there are 4 things particularly mentioned in the preamble: justice, equality, fraternity, liberty. So from Soviet Union, USSR, we've taken the idea of justice. From France, we've taken the idea of liberty, equality and fraternity. Okay, now we are left with South Africa. The South African Constitution has given us the process of amendment, or the procedure for amendment. Concept procedure, the concept of special majority. So 2/3 majority wala jo procedure hai has been provided by South Africa, or has been borrowed from South Africa. Or दूसरी चीज that we've taken from South Africa is that election of Rajya Sabha members. Okay, that how many seats will be given to to people from one particular state in Rajya Sabha. That will be dependent on proportional representation. So election of Rajya Sabha member on basis of proportional representation, this we've taken from South Africa. And lastly we are left with okay, so this is South Africa here, this is France, and this is Soviet Union, and then we are left with Japan, which has provided us with the idea of procedure established by law. Okay, now the point of confusion can be these 4 words which which are there, the 4 words which are there, procedure established by law, due process of law, equal protection of laws, and equality before law. So I will make it simpler for you. So UK rule of law, okay, or equality before law. Okay, USA equal protection of law, equal protection of law and due process of law. And Japan, procedure established by law. Okay, so I'll highlight it for you. So Japan, procedure established by law. Okay, USA equal protection of law and due process of law. United Kingdom, rule of law and equality before law. These sentences or these ideas can be they can be asked in exams as MCQs, and because they sound to be a little confusing, so please remember them, and you can always note down these little things so that you do not get confused. Now next we come up to understanding कि भाई ये सब चीजें अब है क्या. Okay, so we'll begin with the idea of rather due process of law and this particular thing, what you say, due process of law and equal protection of laws. Okay, so due process of law and equal protection of laws kya hai? Both of them are, from the United States Constitution, or the idea is from there, but still इनमें difference है. ये सुनने में थोड़ा सेम तो लगते हैं, but still they are different. अब ड्यू प्रोसेस का मतलब क्या है कि जो आपका ड्यू प्रोसेस का मतलब क्या है कि जो आपकी गवर्नमेंट होगी ना, the government will respect all legal rights, ठीक है, which are there with an individual. So ड्यू प्रोसेस का मतलब है ये क्या क्या चीजें इंश्योर करता है. इट इंश्योर्स फॉर फेयरनेस, इट इंश्योर्स फॉर जस्टिस, इट इंश्योर्स फॉर प्रोसीजरल सेफगार्ड्स. Safeguards in the legal process only. Okay, in the legal process only. Due process की बात करें ना, तो in what process? In the legal process, the government is supposed to be fair. It is to aim to provide for justice, and it will provide, or it will actually ensure procedural safeguards to its people. Okay, so in United States, they mean to say that you cannot deprive anybody with life, or you cannot deprive anybody with life, or his liberty, or his property without any legal procedure, or without an opportunity of being heard. So that procedure, you need to provide him with notice, you need to tell him, you need to follow the rules of audi alteram partem. There has to be a fair judge who is actually answering these questions, or giving some kind of a judgment there, or who's interpreting these questions, or providing solutions to these questions. So you cannot just deprive anybody with life, liberty, without a proper legal procedure, without proper legal procedure. Okay, without proper legal procedure मतलब notice देना पड़ेगा, you will have to give him a hearing opportunity. So these things you need to take into existence, take into consideration, and they cannot be violated. ठीक है, इसका एक और मतलब हो सकता है, हम कह सकते हैं कि इसके अंदर प्रोसीजरल सेफगार्ड्स भी है. ओके, एंड इसके अंदर ये सब्सटैंटिव सेफगार्ड्स भी है. सॉरी, सब्सटैंटिव एस्पेक्ट्स भी हैं. What can be the substantive aspects? कि भाई जो आप लॉ बना रहे हो, ठीक है, प्रोसीजर तो होना चाहिए, बट वो प्रोसीजर होना कैसा चाहिए, ये कैसा होगा ये प्रोसीजर, या ये लॉ किस तरह का प्रोसीजर होगा. तो इट हैज टू बी रीजनेबल, इट हैज टू बी नॉन आर्बिट्रेरी, it has to be, shouldn't be violating anybody's fundamental rights. It should not be in violation of fundamental rights of any person. Non-violative of fundamental rights. So this is exactly, we can say to understand कि भाई ये जो है ये due process of law का मतलब है. अब equal protection of law का मतलब क्या है? Equal protection of law का मतलब है कि भाई जो आपका लॉ है वो सब लोगों को इक्वली ट्रीट करेगा. ठीक है, equal protection of law, it will treat everybody equally without discrimination, without any unequal treatment based on any kind of characteristics of classifications. कि इसका मतलब क्या है? Equal protection of law different है equality before law. Equality before law का मतलब है सब लोग सेम है. ओके, लाइक्स भी सेम, लाइक्स और अनलाइक्स में कोई डिफरेंस नहीं. ओके, मतलब it is not speaking of any level playing platform. So when we speak of equal protection of laws, protection of laws, we are speaking of equality between equals or treating likes in same manner and unlikes in same manner. इसका मतलब है कि आप जो है you can provide for classification, between different people based on differences, but those differences must be reasonably identified. Okay, तो इस classification को कहते हैं, it is known as classification based on intelligible differentia. मतलब ये जो classification है ये reasonable है and this will provide them with a level playing platform. इसका मतलब यही हुआ कि भाई आप एक मछली और एक हाथी को सेम रेस में नहीं दौड़ा सकते. You need to have a separate race where all the elephants will run. You will have a separate race where all the fish will swim. You cannot have one particular race for people who are crippled or who is healthy, and you can at the same time cannot make Usain Bolt run along with the crippled, the old man and the children. So this is what is the idea of equal protection of laws. इसका मतलब है कि जो similarly situated individuals हैं, they should not be discriminated or they should be treated in one manner, and laws will not in themselves. तो इसका क्या है, means you need to treat alike who you will treat similarly situated people in one manner, in a like manner, situated people alike. Okay, so along with that, the laws will not be discriminating individuals on the basis of their race, their gender, their national origin, or their religion. Or so this idea means कि आप ये सब लोगों को impartially provide करें, ये protection impartially provide करें, and they shall have equal access to legal protection. Equality या equal protection law का मतलब एक ये भी हुआ that they are provided with equal access to legal protection and the benefits which might be available. अब what do you think can be the scope? अब इसका scope ये हो सकता है भाई कि देखो जो आपका due process of law है, scope for both due process of law and equal protection of laws when we are speaking with जो आपका due process of law है और आपका equal protection of laws है. Now due process of law में दोनों procedural safeguards भी है या procedural और substantive aspects भी है और procedural aspects भी है. ठीक है, ये fundamental rights को भी primary importance दे रहा है. Fundamental rights are also given importance, so they are also protected. अब इसका focus क्या है? इसका focus है fairness पे, fairness of legal process. It focuses on this. It focuses on fairness of the legal process and the liberty of individuals or the protection of individual rights rather. ठीक है, इसका क्या concept है? The idea here is, or you can say the scope here is, कि you focus on treating individuals equally, okay, without any discrimination. I will not say any discrimination, rather any unjustifiable discrimination. Unjustifiable discrimination. ठीक है, तो they can be discriminated, but अगर वो justified है, it can be justified on what grounds? It can be justified on reasonable differentiation based on intelligible differentia. इसको इन डिटेल हम लोग वी विल बी अंडरस्टैंडिंग इंटेलिजिबल डिफरेंशिया क्या है, रीजनेबल डिफरेंशिएशन क्या हो सकती है, प्रोटेक्टिव डिस्क्रिमिनेशन क्या होती है, व्हेन वी मूव फॉरवर्ड विद द कांसेप्ट ऑफ राइट टू इक्वालिटी अंडर आर्टिकल 14. सो व्हेन वी मूव टू द टॉपिक ऑफ फंडामेंटल राइट्स, तो तब हम इसके बारे में ज़्यादा elaborately डिस्कस करेंगे. For now it is okay to just know a gist of these two concepts and just to have an overview of the meaning of these two things. अब इनकी applicability कहाँ हो सकती है भाई? ये तो हो गया scope, ठीक है, ये तो आपका दोनों का scope हो गया. Now what is the applicability or the application? एप्लीकेशन में हम कह सकते हैं कि जो ड्यू प्रोसेस ऑफ लॉ है आपका, द ड्यू प्रोसेस ऑफ लॉ, इट अप्लाइज टू ऑल लीगल प्रोसीडिंग्स. एप्लीकेशन ऑन ऑल लीगल प्रोसीडिंग्स, सो दैट क्यों देनी है आपको ये हर लीगल प्रोसीडिंग पे आप अप्लाई क्यों करना है? सो दैट इंडिविजुअल्स हैव प्रॉपर नोटिस, दे गेट अ चांस ऑफ फेयर हियरिंग, दे गेट अ चांस टू बी ट्रीटेड फेयरली और treated in a just manner in a legal process. ठीक है, और ये जो है ये आपको किन चीजों से बचाता है? to in all legal proceedings give proper chance of representation कह लो या हियरिंग कह लो या एक तरीके से प्रिंसिपल्स ऑफ नेचुरल जस्टिस कह लो. और दूसरी चीज है इट प्रोटेक्ट्स against arbitrary government. It protects against arbitrary government actions. Okay. अब जो equal protection of laws है, on the other hand, इसका पर्पस है कि ये substance के ऊपर लगता है, मतलब ये law के ऊपर लगता है, applies on, ये क्या है, proceedings के ऊपर, procedure पे लग रहा है, ये applies on law, not the procedure, the substantive law or the substance of law. तो ये क्या करता है? It prohibits discrimination and ensures equal treatment. Equal treatment कब? Similar circumstances. Okay, similar circumstances में. So we are just trying to say this कि भाई जो due process of law है और equal protection of laws hai, they are different concepts. Both of them are provisions, or you can say elements which have been borrowed from USA, but they are essential. क्यों they are essential? Both of them क्योंकि इनका aim एक तरीके से दोनों का एक ही है. They try to aim to bring up fairness, justice, maintain and uphold justice, and protect rights of individuals in legal system. Okay, they're somewhere different, but still they both together, they are trying to uphold the ideas of fairness, they are trying to uphold the ideas of justice and protect rights in the legal system, and that is why they become very important from the aspect of being features of the Constitution. Okay, so now when we move forward, अब इसके अलावा जो हमने दूसरे हमारे जो कि हमने वो करे हैं the features. Now we'll start with we will actually start with a general idea कि भाई हमने fundamental rights को भी अपना एक what you say important feature बोला है. It is one of the salient features of the Indian Constitution. Now what about fundamental rights? Now fundamental rights जो है, they are also important features of Indian Constitution, or they are, one of the features of Indian Constitution provided in Part 3. Okay, they are described from Article 12 to 32, और इनको Magna Carta of Constitution बोला गया है. They are known as the Magna Carta of the Constitution. तो Magna Carta क्या था? It was a document from 1215, from the old times, or from the 12th century in England, जिसने की monarchy की जो powers थी उनको limit कर दिया था, and जो subjects थे उस monarchy में उनको थोड़े rights दे दिए थे. तो इस डॉक्यूमेंट को एक बहुत इंपॉर्टेंट प्रीकर्सर रैदर बोला जाता है, जो कि डायरेक्टली फंडामेंटल राइट्स से रिलेट नहीं करता, बट स्टिल द इम्पोर्टेंस व्हिच वी प्रोवाइडेड टू दिस इंस्ट्रूमेंट इज दैट in everywhere in the world, few rights or few entitlements of the subjects in the monarch's institution got to be recognized. ठीक है, तो अब इंडिया में when we speak of right, the justifiability या fundamental rights जो है, you also have one right as fundamental कि भाई you can go and get them enforced in the court of law. तो आपको आर्टिकल 32 में जो है, रेमेडीज, कॉन्स्टिट्यूशनल रेमेडीज जो आपको मिली है, which are also known as heart and soul. तो ये B.R. Ambedkar ने बोला था, it is known as heart and soul of the Indian Constitution. So what are the few cases which we can discuss which tell about that they are justifiable, or which tries to provide more push and understanding कि भाई fundamental rights की justifiability क्यों important है, या courts ने उनके बारे में क्या चीजें बोली हैं. So इसके अंदर हम पहला केस हम केशवानंद भारती ले सकते हैं. Okay, we can take the Keshwanand Bharati judgment versus State of Kerala 1973. तो ये लैंडमार्क है कॉन्स्टिट्यूशन हिस्ट्री में, बिकॉज इट इज ऑल्सो कॉन्सेप्चुअलाइज्ड द बेसिक स्ट्रक्चर डॉक्ट्रिन, और इसके अंदर फंडामेंटल राइट्स के बारे में कोर्ट ने ये बोला है कि भाई जो पार्लियामेंट की पावर है अमेंडमेंट की वो अनलिमिटेड नहीं है, एंड देयर आर सर्टेन बेसिक फीचर्स ऑफ द इंडियन कॉन्स्टिट्यूशन व्हिच कैन नॉट बी एब्रोगेटेड और डिस्ट्रॉयड, एंड fundamental rights are basic structure. Okay, they are basic structure and they cannot be abrogated or destroyed. However, but it can be done through a constitutional amendment, but few fundamental rights which are so essential they cannot be removed. Of course, right to property was a fundamental right, it was removed, but the procedure or the requirements has to be reasonable enough. Okay, the procedure has to be reasonable, the procedure has to be fair, it should not be arbitrary in nature. उसके बाद केशवानंद भारती के बाद about the justifiability and the value of fundamental rights, we can have another case which is Menka Gandhi case. Okay, the Menka Gandhi judgment, Menka Gandhi versus Union of India judgment of 1978. तो इसके अंदर कोर्ट ने बोला है कि भाई when you are speaking of fundamental rights, rather right to life की बात करी है. ओके, सो दे सेड दैट राइट टू लाइफ जो है उसके अंदर लिविंग विद डिग्निटी इज इंक्लूडेड. ओके, लिविंग विद डिग्निटी मींस कि you do not just mean to have a right to life means कि आप पैदा हुए और मर गए. It does not mean mere animal existence. It has to be living with dignity, and कि जो भी procedure है which is established by law, procedure by law has to be three things, has to follow three things. This has to be fair, it has to be just, and it has to be reasonable. Okay, और एक और चीज मेनका गांधी में बोली थी कि arbitrariness and equality, arbitrariness and reasonableness, arbitrariness and equality are enemies. Okay, they cannot go together. if something is arbitrary, it will not ever try to maintain equality, or it will never try to maintain, or it will never aim to provide for justice in society. So equality and arbitrariness are enemies, rather they are sworn enemies. Okay, and they cannot go hand in hand. उसके बाद हम पुट्टास्वामी का केस इसमें देख सकते हैं, the 2017 judgment or the Aadhaar case or the case on right to privacy. So this has also held कि भाई, you know, when you are speaking of fundamental rights, you also need to give them a wider interpretation, because when you are speaking of fundamental rights, you're not just speaking of rights merely, it means meaningful enjoyment of fundamental rights. Then you know, one of the latest cases, जो नवतेज सिंह जौहर का case है, that also we can try to understand from the perspective of why they are important. You know, in case if something which is violating fundamental rights, that can be, you know, nullified by the Supreme Court or held ultra vires, तो इसके अंदर जब कोर्ट ने 377 को partially you know decriminalize किया, so when it decriminalized the consensual same sexual relationships, तो कोर्ट ने बोला था कि भाई ये इसलिए हम कर रहे हैं because it is, you know, violating the rights to equality, privacy and dignity. And when you are speaking of equality, or when you are speaking of any kind of a procedure, any kind of a law, you need to see that it is reasonable and it is not arbitrary to one strata of society. ठीक है? Now, when we are speaking another feature, let's come to, अब हम बात करते हैं independence of judiciary की, ठीक है? अब हम independence of judiciary की जब बात करते हैं, या we can say, you know, the Indian Constitution is independent and the judiciary has the power of judicial review, and it is independent judiciary, rather इसको guardian of constitution भी बोलते हैं. Fine, it has a judicial review also. Okay, you can refer to article 50 for independence of judiciary also, and offer also separation of powers भी बताता है, and independence of judiciary के बारे में भी बताता है, independent judiciary के बारे में भी बताता है. So इसमें हम we can take up the first judge's case, which is also known as or the name, real name is SP Gupta versus Union of India. 1981 का एक केस है, SP Gupta versus Union of India, 1981 का केस है ये, also known as the first judge's case. Okay, तो इसके अंदर जुडिशियल इंडिपेंडेंस के बारे में, जुडिशियल इंडिपेंडेंस एज अ प्रिंसिपल ऑफ द कॉन्स्टिट्यूशन. ओके, इंडिपेंडेंस एज अ कॉन्स्टिट्यूशनल प्रिंसिपल. This was affirmed here. तो सुप्रीम कोर्ट ने ये यहाँ पे ये बात करी थी कि when you are speaking of appointment of judges to higher judiciary, तो वो judiciary को खुद से ही करना चाहिए, and you know, it can take or it can do consultation with the executive, but वो खुद से अगर उनको अपॉइंट करेंगी, and appointment of judges to the higher judiciary should be done by judiciary itself in consultation with the executive, and this will only, you know, actually ensure the independence of judiciary in India. उसके अलावा then there are other cases as well which we can speak of, कि भाई judicial review के क्या cases हैं, या why do we call you know, the cases of judicial review, or what is the value of judicial review in India, or how it is also you know, another basic feature, or rather feature of the Indian Constitution. ठीक है, तो judicial review की जब हम बात करते हैं, तो judicial review as a yes, when we speak of judicial review and we speak of when we speak of judicial review, we speak of it as a feature of the constitution, a salient feature of the constitution, and also a basic structure. ठीक है, हम इसको basic structure of constitution भी मानते हैं, we do accept that. तो ये चीज की ये basic structure of Indian constitution है, ये सबसे पहले तो judicial review basic structure of Indian constitution है. This was said in Indira Gandhi versus Raj Narayan's case. Okay, in 1975, और the concept of judicial review जो है, it was taken from USA, और USA में इसको establish किया था Lord Marshall और Justice Marshall ने, and it was done in which case in USA, Marbury versus Madison, 1803 का केस है. Marbury versus Madison, 1803 का ये judgment है, wherein judicial review is considered as an essential or a prime principle of the constitution. और इसके अलावा आप कह सकते हो कि it is from there that in order to understand the spirit of constitution, judicial review is very, very important. Okay, now other features that we were discussing, तो इसमें हमने preamble की बात भी करी थी. Okay, the preamble of the Indian Constitution. अब preamble क्या करता है भाई? जो preamble है वो fundamental structure बताता है. Fundamental structure बताता है Constitution का. ठीक है? It brings out basic ideals and objectives. Brings out basic ideals and objectives, और चीजों को highlight करता है. किन चीजों को highlight करता है? Values of justice, equality, fraternity, liberty. These things are provided. तो एक तरीके से ये एक guiding light है या एक guiding principle है किस चीज के लिए? To interpret and implement constitution. Okay. Is it a part or not of the constitution? Yeah, of course it is validly a part of the constitution. It provides introduction to the constitution and integral part है ये constitution का. Integral part है. इसको detail में हम जब हम preamble के बारे में ज़्यादा elaborately पढ़ेंगे दूसरे sessions में तब करेंगे. But of course it is an integral part of the constitution, and Keshwanand Bharti में it was held this, okay, that it is a part. ठीक है, उससे पहले एक जजमेंट आई थी बेरुबेरी यूनियन में 1980 की जो जजमेंट थी, उसमें बोला था कि 1960 की जो जजमेंट थी उसमें बोला था कि भाई जो आपका केशवानंद प्रियम्बल है, इट इज नॉट अ पार्ट ऑफ द कॉन्स्टिट्यूशन. बट 1973 में बेरुबेरी यूनियन केस वाज ओवररूल्ड बाय द सुप्रीम कोर्ट इटसेल्फ, एंड इट सेड दैट इट इज a very integral part, and it can be used to interpret the provisions. Fundamental rights we've understood कि भाई दूसरा कि वो कैसे justifiable है. Directive principles की अगर हम बात करें, now when we are speaking of the directive principles, we just discussed कि वो एक guiding light की तरह इस्तेमाल होते हैं. They are non-justifiable, but they help the state, they guide the state in formulating the policies and the laws which will help it to become a welfare state. ठीक है, तो ये जो principles इसके अंदर जो principles provided है to promote social justice, economic welfare, they try to aim at the overall well-being of the citizens of the country. When you have to in order to understand the meaning of or the value of directive principles, कि भाई they promote social justice, or these principles aim to promote social justice. The case of Olga Tellis versus Bombay Municipal Corporation 1985 becomes important. So when we are speaking of DPSPs, we can say they are prime guiding principles. What is wrong with my pen? Prime guiding principles, ठीक है, for state in formulating laws and policies. ठीक है? Why? Because they aim, क्या aim करते हैं? To promote social justice, economic welfare, and overall well. Okay, together you can say it. Overall well-being is being promoted by them. So when we speak of Olga Tellis versus Bombay Municipal Corporation का case है, Olga Tellis के case में ना livelihood or right to livelihood is a fundamental right. This was held. So you can say कि भाई right to have a livelihood with a DPSPs. So DPSPs are important कि now some DPSPs which are so necessary for your welfare or so necessary to promote justice in society are being interpreted by the Supreme Court as part of life, okay, or as part of right to life. So sometimes the courts actually what they do is they try to give a wide interpretation to right to life, or they try to bring it within the domain of fundamental rights. Okay, so Olga Teres के केस में जैसे हुआ कि भाई जो आपका livelihood है, concept of livelihood or right to earn a livelihood, right to livelihood was taken as Article 20, was taken as under Article 21. A wide interpretation was given to Article 21 to include a guiding principle in it within its meaning. Okay, so this we can say is the relationship also between fundamental rights and directive principles. We will do it in a detailed manner when we do these topics, or we understand these topics from a separate point of view and only exclusive point of view. Now speaking of parliamentary system of government, हमारा एक parliamentary system of government भी हमारा एक essential feature है, ठीक है? Parliamentary system. Okay, this is also an essential feature of the Indian Constitution. Now, speaking of the parliamentary system, तो जब हम इसकी बात करते हैं, अब इसका मतलब क्या है कि भाई आपका जो president होगा in parliamentary system, what will happen? The president will be head of state. Okay, prime minister will be head of government. ठीक है, इसके बाद तुम्हारे पास एक जो हमारा पार्लियामेंट्री सिस्टम है, ये कैसा स्ट्रक्चर एस्टैब्लिश करता है? ये एक बाइकैमरल स्ट्रक्चर को एस्टैब्लिश करता है, ओके, जिसके अंदर दो हाउस होंगे, राज्यसभा, लोकसभा, ओके, एंड बाइकैमरल स्ट्रक्चर मतलब बाइकैमरल लेजिस्लेचर एट सेंट्रल लेवल, मतलब पार्लियामेंट at center which has two houses. Now when we are speaking of the parliamentary system, so this is something ki bhai, when we spoke ki what is the role of the constitution, it provides for institutions, it provides for organs. So this is one organ, okay, it is one feature that this provision, this institution, ki how the government will be set up, what will be the structure, what will be the framework, who will be the head of the state, who will be the head of the government, who will be included within the meaning of the union parliament. All those things are mentioned, and that idea is now we've taken it from the British Constitution itself. ठीक है, उसके अलावा the federal structure. Okay, we are left with the federal structure. I guess rest of the cases we've we have covered almost majority of them. So when we are speaking of the federal structure, ठीक है, federal structure या फिर आप कह दो quasi federal. Okay, quasi-federal as a feature. Now, when you speak of quasi-federal structure, or you say a federation with strong center, ठीक है, a federation with strong center, and we've taken it we've taken it from Canada. तो quasi federal है, या आप इसको hybrid federal भी कह सकते हो, hybrid federal system. ठीक है, तो इसका मतलब क्या हुआ कि भाई, इसका मतलब ये हुआ कि जो इंडिया है, इंडिया इज अ यूनियन ऑफ स्टेट्स, कि इंडिया इज अ यूनियन ऑफ स्टेट्स एंड नॉट अ फेडरेशन. इंडिया इज अ यूनियन ऑफ स्टेट्स एंड इट इज नॉट अ federation of states. We are only concerned about the units as a part, कि these are indestructible parts of the union. ठीक है, so when we speak of Article 1 here, जब हम Article 1 की बात करते हैं, which provides India, that is Bharat, shall be a union of states, तो उसका मतलब क्या होता है कि the Indian Constitution makes it as a indestructible union. मतलब कि इंडिया जो है या भारत जो है is a indestructible, it cannot be destructed, it indestructible union of destructible units. Okay, now this is how Article 1 was interpreted by the Supreme Court. अब ये जो statement है, ये Supreme Court ने बोली थी in 2007 in the case of Raja Rampal versus Honorable Speaker. Honorable Speaker. So the courts or the Supreme Court has understood in a manner कि भाई, the states have accepted the supremacy of the union. They cannot get away, they cannot separate from the union, they cannot break off. They've not come up into a agreement, जो कि फेडरेशन का मतलब होता है. फेडरेशन का मतलब है that you mutually agree to come within the supremacy, and if you wish to get away with it, if you wish to secede from it, you can also sever from it. But in the case of India, India is a union of states. The states can come up within the federation, but they do not have a right to get away. They cannot get away from themselves, but they can be they can be clubbed together to make one unit, or they can be broken together to make two units, लेकिन वो रहेंगे इंडियन यूनियन के अंदर. इसका मतलब होता है क्वाज़ी फेडरल, या आप इसे कह सकते हो लूज फेडरल, लूज फेडरल स्ट्रक्चर. ठीक है, लूज फेडरल स्ट्रक्चर. Okay, where the supremacy or the strong or the hold is with center. A loose federal structure where the hold is with center or the hold is with union, तो इसको हम कहते हैं a quasi federal structure. Okay, और ये कि इसका ये characteristic है, it is the there is one case which speaks of the characteristics of federal structure in India. Okay, or the ideas of federalism in India. So there's this case of state of West Bengal का ये case है versus केशोराम इंडस्ट्रीज. तो ये एक केस है which tells about the characteristics. तो ये क्या characteristics बताता है? So the characteristics which about the federal structure of India is कि भाई, the characteristics is that it is quasi federal. Okay, that it is hybrid federal. These are the two characteristics which are provided by the case of West Bengal versus Kesoram Industries. So I think we've almost covered everything which was planned for today's class, and we've done why the importance of fundamental rights we've done. We've done the features as in the duties, how they are important, the concept of secularism, how it is important from this angle, or इसके अलावा we've discussed the concept of equality before law and equal protection of laws we've done. Then we understood the concept of Magna Carta. This we've also understood. The DPSPs we've certainly have tried to understood what do we mean by DPSPs. Then we also have covered for that instance the areas or the concepts which have been borrowed from other countries. Those also we've referred for our knowledge, and I think we will wind up here only. So probably from the next class or the next session, we will start with the concept of Indian preamble, or how is Indian preamble an integral part of the country? What is the story behind the bringing preamble to be understood as an integral part, or पहले था कि नहीं था, कौन से cases ऐसे क्या हुआ, what is the story of those cases? So we'll begin with those things in the next session, and thank you for having your attention, and that's all for this class. Thank you and have a good day. Good evening, everybody. Thank you.